Lesson 8. The Administration of Justice in Upper Canada and New France. This lesson allows for a comparison of the justice systems in Upper Canada and New France, one an English colony and the other a French colony. Paul Romney's article on the evolution of Upper Canadian justice in the 18th and 19th centuries examines how justice was administered in the province and points to the importance of the colonial link to England in shaping legal professions and institutions and reinforcing the political climate. As a colony, Upper Canada, that is, modern-day Ontario, might be expected to have transferred and adopted legal traditions from the mother country. This was particularly relevant for a colony such as Upper Canada, since it was so sparsely populated, underdeveloped, lacking major urban centres and so on, in comparison to England. This was, after all, from a European point of view, the New World. By the Canada Act, or Constitutional Act of 1791, the province of Quebec was divided into two new provinces, Upper Canada and Lower Canada. While both Canadas maintained the criminal law, the civil law in Upper Canada was changed. Though now an English colony, Quebec, or Lower Canada, was allowed to maintain its traditional civil law, which dealt with the relations between citizens such as matters of contract, property, landholding, and so on. Though it was forced to adopt English criminal law, which dealt with crimes or actions deemed to be against the state. It made sense for the English civil law to be adopted in Upper Canada, since there were few French descendants tied to the colonial French law. There was, of course, immigration from the British Isles into Upper Canada, and there was also an influx of former English subjects who fled the Americas following the American Revolution, these loyalists who desired to remain English subjects rather than follow the new American Republican experiment. The type of law or sets of law instituted in a province or state will help shape its social and political outlook. To this day, Quebec has maintained its own civil code, which can be seen as part of the French heritage, along with language, history, and other customs which help make Quebec to be judged a distinct society within Canada. In Upper Canada, however, it made sense to use English criminal and civil law to ensure that it became like a little England. Indeed, one of the ways in which the British Empire was expanded and made more cohesive was to extend the use of English law into its new states. Think of former British colonies who used parts of the English common law in their legal systems: Canada, America, India, Australia, and so on. To make a loyal colony out of Upper Canada, English law was paramount. It enforced English-style property rights and landholding practices, and differentiated itself from the Republican nation on its borders, the United States. The first Lieutenant Governor, John Graves Simcoe, wished Upper Canada to become like its English motherland, and the way justice was administered in the colony would promote respect for authority, the sanctity of property rights, and emphasis on the possession of land and property as a requisite for participation in law and in government. As historians continually have noted, Ontario and Upper Canada before it were inherently conservative societies that tended to defer to the status of authority and uphold the status quo. The fit was not always a harmonious one. As the article notes, some English laws adopted in Canada did not make much sense. England was a nation based upon landed estates owned by powerful families who employed lots of labourers and rented their land to smaller farmers. In this system, there were game or poaching laws, which stated that animals such as deer or hares and so on found on a landowner's estate belonged to that landowner and could not be shot or taken by others, who were therefore called poachers. These game laws were brought to Upper Canada, but did not make sense because although some families owned huge tracts of land, there was more than enough wild game to go around, and there weren't many tenant farmers. One of the most infamous aspects of the English criminal law, which was adopted to the Upper Canadian justice system, was the so-called Bloody Code. These were a series of laws numbering into the hundreds, which had as their punishment the death penalty. Many of these were for small thefts, and the fact that so many property crimes and specific small theft infractions carried the death penalty clearly showed the English obsession with protecting property rights. As the text notes, in many cases, the sentence of execution would ultimately be reduced. It was a harsh justice system, which Upper Canada adopted wholesale in 1800 and lasted into the 1830s. The establishment of the Law Society of Upper Canada in 1797 would aid in the creation of an elite tied to establishment values. As Canada would have no landed aristocracy, with titles such as Duke and Earl, as European countries had, lawyers would be part of the conservative political and social life of the colony. The Law Society would create a regulated, exclusive profession who would become establishment forces. This was the intention of supporters of the Law Society, though lawyers would come to dominate both conservative and reform political parties in the province. Lawyers in Upper Canada did indeed become political leaders, whether at the provincial level or, in the case of Sir John A. Macdonald, Canada's first Prime Minister. For the purposes of this lesson, you do not need to study the sections on creditors and debtors and the discussion on the Court of Chancery, as it is too arcane for our purposes. The discussion on policing will be elaborated upon in the following lesson when we examine models of policing and policing specifically in Toronto. How did the administration of justice differ in Quebec? It is not a direct comparison, as the second article deals with Quebec as a French colony, that is, before it became an English colony. This reading does, however, highlight some major differences between the French and English legal systems. For the purposes of this lesson, you should focus primarily on the section on the criminal law. No need to get bogged down in the litany of French legal terms, the judicial institutions in New France, or the position of the notary. The legal system implemented in New France was based on the legal tradition from around the Paris, France region. Since historically France did not develop a strong centralized state for a long time, there were diverse legal customs and traditions throughout the nation, though the system in place around Paris was eventually chosen as the national model, the Coutume de Paris. Unlike the experience of the English with their Canadian colony, in the colony of New France, since there was no other large European populations with their own legal traditions in place when the French took over the land, the French crown was free to impose a new order on the colony. There were no long-established legal customs, or even powerful interest groups like merchants or landowners to placate. As such, the French system could be imposed. One striking element of the French legal system as imposed in New France was its authoritarian and paternalistic nature. It especially upheld the interests of the crown, the church, and male domination. The law in New France, though this was largely true of English law and the law in Upper Canada, sought to reinforce the patriarchal family, that is, the family unit headed by the father and or the husband. This was a symbolic extension of how the king ruled over the nation, and expected obedience to the king's will. The importance of the Catholic Church was clearly evident in the French legal system, as children could be disinherited from the family if they left the Catholic Church. Looking at the criminal law in New France, we see other differences from the English system. For one, judges had different responsibilities. One of which that stands out is the fact that French judges were not only supposed to evaluate the facts and evidence in a case, but were also expected to actually gather proof and evidence. We might see this as a judge not being particularly neutral or disinterested in his role in the criminal case. Other notable elements of the French criminal justice system were that in criminal cases, witnesses would be paid for their testimony, paid in accordance to their social rank and therefore value in society. A laborer would be paid something like a day's wages, whereas higher-ranking men, such as merchants and professionals, would be paid 5 to 10 times this amount. Again, illustrating the close relationship between the church and the law in New France, the church could be utilized for the state's purposes in gathering witnesses for criminal cases. The court could order priests to announce from the pulpit in church information about a particular crime and calling on anyone with knowledge of it to testify. The penalty for someone ignoring this request and not coming forward if they had knowledge of the crime was, indeed, excommunication from the Roman Catholic Church. Excommunication exiled someone from the church, barring them from taking any of the church's sacraments, and would also mean social ostracism within the society. Perhaps the most striking difference between the French and English criminal law systems lay in how the accused was treated. For one, the accused would be interrogated by the authorities and a case made against him or her before he or she was actually formally told of the specific crime they were accused of. The reasoning behind this was that the accused would be less able to concoct a false story or alibi or come up with other misleading information if they did not know exactly of what they were being accused. The use of torture was also part of the system, and this clearly stands out to us, though the author makes clear that though part of the system, torture seems to have been rarely used. Torture was used when there was great evidence pointing to the guilt of a person, but the accused would not confess to the crime. The importance of a confession in the French system is another link to the religious overtones in the law. One was to confess one's guilt, just as one confessed one's sins at confession in church. In future lessons, we will examine the evolution of punishment from systems like the French system that used torture and corporeal punishment more generally as part of the criminal court and punishment system, to systems that locked people away in prisons, which were called penitentiaries, that had the dual purpose of both punishing and reforming the criminal.